Okay, Colleen, go ahead.
Welcome to today's program. Copies of the slides, a link to the recording, and the CLE verification form will be emailed to you in the days following the webinar. During the program, a CLE code will be read aloud, and you will be required to include this code on the CLE form. Throughout the webinar, please feel free to type your questions into the Q&A box on your screen. Now, I'd like to turn it over to Michael Wexler.
Good morning and good afternoon, depending on where you're viewing this presentation from. We thank you for joining Seyfarth Shaw and my colleagues, Robert Milligan and Josh Salinas today, so that we can provide you, as we have for many years, with a review of the prior year with regard to trade secrets, non-competes, and computer fraud. Next slide, please. On the screen in front of you, you'll see a legal disclaimer. We are not forming a attorney-client relationship or providing legal advice. The material discussed is for informational purposes only. And if you need further information, you should consult your own lawyer concerning your specific situation and any specific legal questions you may have. And as Colleen mentioned, if you have some questions, certainly you can type them in the Q&A and we'll try to cover those topics generally if there's something there. As you can see in front of you, Josh Salinas, my colleague, is in a senior associate in our Los Angeles office with a number of years of experience in this topical area. And Robert Milligan, partner, also in Los Angeles, is also co-chair of our Trade Secrets, Non-Compete, and Computer Fraud group, along with myself. So next slide, please. Today, we'll try to cover, as we usually do, a number of topics with particular interest this year in legislative history, regulatory efforts. We'll start with restrictive covenant legislation and talk about that. We'll then jump into additional legislation, and in particular, what's going on with the new Biden administration and how that may affect non-compete and ultimately trade secret issues. We'll talk to you about some of the notable recent restrictive covenant cases during the past year, as well as the Defend Trade Secrets Act, an overview where we've been and what's of note over the past several years. We'll then jump into some of the trade secret civil and criminal cases, as we always do. And then finally, we'll give you some practical considerations for drafting and updating agreements, especially this past year, as there have been obviously numerous challenges and a lot of remote workforce. So with that, we'll jump into the next slide, and I believe that would be Robert, I think.
Oh, it's Josh.
It's Josh, sorry.
No problem. So with regards to state legislation on restrictive covenants, we're continuing to see more and more states either enact or amend their statutes governing non-competes. We've highlighted with the last couple of years in our year-end review webinars that we're seeing these emerging and developing trends with more and more states either narrowing the scope of enforceable non-competes, trying to implement some certain income or salary thresholds, or just providing exceptions and exclusions for certain professions. We're going to cover some of the notable changes that we've seen this past year, but one of the things you can look forward to is we are updating our 50-state survey that will be coming out and incorporating all of these new changes. Next slide. So with Oregon, Oregon already had a salary income threshold, which requires that for enforcing a non-compete against an employee, that employee had to have, at the time of termination, be earning a median income for a four-person family based on the Census Bureau, which I believe is around $97,000 a year. Oregon also already had some notice requirements in which an employer must inform employees in a written employment offer at least 2 weeks before the first date of the employee's employment if there's a non-competition agreement that's going to be required as a condition of employment. But alternatively, the employer can also impose a non-compete when there's a subsequent bona fide advancement of the employee. With this the new changes, now you have this kind of bookended post-employment notice requirement. And so the for any non-agreement entered either into, on, or after January 1st, 2020, the employer must provide the employee with a signed written copy of the terms of the non-competition agreement within 30 days after the termination of employment. So no pre-hire notice requirement, but now you have this 30-day post-termination requirement. One of the takeaways to be aware of is that companies should consider their practices and policies for providing copies of non-competes to departing employees. Sometimes the company may not provide a copy of the agreement to the employee until they think the employee is competing, perhaps through a reminder of obligations letter. And so in this case, because there is a 30-day deadline to provide a written copy of the agreement to avoid it from becoming void, you should consider when you're going to be providing that agreement, so you don't pass that deadline to provide the notice. Next slide. So we're going to be covering a number of states that implemented changes to narrow or restrict the enforceability of non-competes. Louisiana actually went against the current this past year, and they actually expanded the enforceability of non-competes instead of narrowing it. In Louisiana, the non-compete statute applies to every agreement that restrains someone from engaging in any profession, trade, or business, and provides that such an agreement is null and void unless there's specific exceptions that apply under the statute. With respect to businesses, prior to this new 2020 amendment, a corporation, partnership, or LLC could only enter into an agreement to stop a shareholder, partner, or a member from owning or being an interest holder in a competing business. These entities could not, however, enter into an agreement to prevent such individuals from merely being employed with a competing business. But now, under these new 2020 amendments, a corporation, partnership, or LLC may enter into agreements with their shareholders, partners, and LLC members that restrict them from taking equity stakes in a competing business and or merely becoming employees with a competing business. And so with certain entities, corporations, partnerships, LLCs that already have agreements with certain persons that reside in Louisiana, it's time to potentially consider reviewing and perhaps amending those agreements to the extent the coverage of the restrictions to those persons who merely could become employees of established competitors. Next slide. With Rhode Island, the Competition Agreement Act became effective last year, and it has these certain exceptions to where you cannot enforce a non-compete agreement. And so the list provides low-wage workers, which is defined as 50% of the federal poverty level for individuals that's established by the U.S. Department of Health and Human Services. It also is unenforceable against non-exempt workers under the FLSA. Non-competes are not enforceable against students, and that's interns or short-term employees who are working while enrolled in college or school. And then also individuals who are 18 years old and older, or 18 years old and under. And then also there's exceptions that this does not apply to non-disclosure agreements, non-solicits, sale of business agreements, and some of the other things that are provided on the slide. Next slide. With Virginia, Virginia continued the trend with banning agreements with low-wage workers, and so it prevents non-compete agreements with who are low-wage earners, but any agreements that restrain, prohibit, or otherwise restrict their ability to compete with a former employer after termination. One thing to note is that it does not appear that this the Senate bill actually directly addresses non-solicitation agreements. Next slide. Washington also joined the trend of imposing a salary threshold for certain workers. And so with independent contractors, the threshold is $250,000 a year, $100,000 a year for employees. Any agreement that's over 18 months in duration is going to be presumed to be unenforceable. And then you have some additional key requirements. There is an imposition of a mandatory garden leave. And so if the employer wishes to enforce a non-compete against an employee, that is terminated as a result of a layoff, the employer must provide compensation that's equivalent to the employee's base salary at the time of termination, of course, minus compensation that may have already been earned through subsequent employment for the entire period of enforcement. Washington took some inspiration from California's choice of law restrictions. And so under Washington, they have a restriction where you cannot have a non-Washington choice of law provision and use that against a Washington employee to otherwise enforce the non-compete agreement and circumvent these non-compete restrictions. And then one kind of unique creative requirement is now you have this minimum $5,000 in damages, including attorney's fees and costs, if the non-compete is reformed, rewritten, modified, or only partially enforced. And so what this does is it discourages employers from using an overly broad non-compete with the expectation or hope that a court would eventually just rewrite it or reform it to the extent it becomes enforceable. So now there's this essentially a $5,000 penalty to try to disincentivize that type of overbroad reach. Next slide. And then lastly, Indiana implemented some restrictions with respect to non-competes for licensed physicians in the state. The real goal and purpose of this was to really protect the patient's rights to choose their physician, their treating physician. And so for a non-compete to be enforceable against a physician licensed in Indiana, the agreement must have certain provisions. One, there must be provisions that requires the employer of the physician to provide the physician with a copy of any notice that either concerns the physician's departure or was sent to any patient seen or treated by the physician within the last 2 years before the physician's termination of employment or the contract. Second, there has to be a provision that requires the employer to, in good faith, provide the physician's last known or current contact and location information to a patient who either requests such information or had already been provided to a patient who had been seen within the past 2 years. Next, there's two provisions, the access to medical records. And so you need to have a provision that provides the physician with access to or copies of any medical records associated with the patients described above upon receipt of that patient's consent. And then also there needs to be a provision that prohibits the providing of patient medical records in a format that materially differs from how it's regularly stored in the routine and ordinary course of business, unless mutually agreed. And so this was targeted to prevent companies who may be not providing either a digital or paper copies of the records. And then lastly, there has to be a buyout option for the physician has to have the ability to purchase a complete and final release from the terms of that non-compete at a reasonable price. And so these are just a couple of the changes that we've been seeing. With that, I'm going to turn over to Mike Wexler, who's going to be talking about some of the additional potential changes or attempts to restrict non-competes, including on a federal level.
Thank you, Josh. Next slide, please. So now we're going to start talking about some of the more broad regulatory efforts that are being used or at least being investigated with regard to non-competes and how the Biden administration, some data and information that has come out of positions that that Biden has taken prior to being elected and activities that are going on currently with regard to non-competes. So next slide, please. One thing we can look at, which is related, but somewhat specific, is in DC, Washington D.C. That is, there is a ban on non-competes, and it was signed into law in early January here this year. We believe it'll take effect in the fall of 2021. That's not exactly clear to us yet. And what it does is it essentially finds that non-competes are unenforceable in Washington, D.C. under, in very specific, in all circumstances, but with a couple exceptions. For example, there's some exceptions for babysitters and certain medical professionals, which is somewhat odd, but that's what the statute says. And it also, which oddly is, it includes in-term covenants, meaning if you have someone who's an employee and they sign a non-compete that says while they're working for you, and if the law of Washington, D.C. applies, then under this law, that non-compete would be unenforceable, which is somewhat of an odd result, because when an employee works for you, in many instances, and this can be different by state and different by level of employee, but in many instances, someone who works for you, it would be potentially a breach of fiduciary duty, maybe even bad faith, with regard to someone working for you and working for a competitor at the exact same time while they're employed by your organization. So this seems to be an odd provision within this law, but it is what it is. It also prohibits employers that essentially would prevent employees from working for other employers as well, which is another form of prohibiting non-competes. But again, that's one of the specific provisions. And then, of course, it also has within the signed law, it has notice requirements. It's not retroactive, so it's prospective to when it takes effect. It has some anti-retaliation protections, and it expressly doesn't apply to confidentiality agreements, which at least allows you some something you can do in Washington, D.C. If your business is based there as your choice of law. But it is an interesting statute that's been signed into law in D.C. Next slide, please. One of the things that's being looked at is a federal law to potentially ban non-competes in some form. Some of you might remember that in the Obama administration, there was a white paper that was done with regard to non-competes and the effect of non-competes, at least according to the white paper, on employees and business and the like. Now, President Biden actually, in his position statement or some of his policies and plans that you could find online, he basically indicated that he wanted to eliminate non-compete clauses, and the quotes here: eliminate non-compete clauses and no poaching agreements that hinder the ability of employees to seek higher wages, better benefits, and working conditions by changing employers. And so it also then went into some of the statistics here and information that they believe are accurate with regard to information that would support the idea of having a federal ban. In the end, when you look at some of the information here and you think about what's going on, and we'll talk a little more about this, but you have a number of states, I think it's up to 18 states, and either Josh or Robert will correct me, but it's approximately 18 states that have passed some form of a low wage earner prohibition on non-competes, meaning that someone who's earning under a certain threshold in that state is not subjected to a non-compete agreement. So there seems to be a trend in that, and the policy here may actually, really address that situation. But what's going on currently is that that senators in the U.S. Senate, they have engaged the USGAO, and the USGAO is currently engaging in an investigation, fact-finding, et cetera, doing research for the senators on this topic, and they're interviewing all different organizations and folks who would have various opinions and information with regard to the effect of some kind of federal ban, some partial ban, no ban, who is benefited, et cetera. So that's going on currently, and it's something that everyone should be aware of, and potentially, depending on your view, contact when the time's appropriate your legislators if you have a view on this issue. Next slide, please. Some of the issues that are being considered and looked at is the notion of federalism, that should the federal government have a ban that's nationwide on non-competes in some form, when currently there's 50 states with 50 different sets of laws with regard to non-competes. One argument being, well, this is something that they could do nationally and federally. The other issue, the federalism issue, is that should the federal government be legislating for states, whereas state legislatures know their population, their businesses, their wage earners better than the federal government may know, and thus it would seem to make sense to allow states to, as what has always happened, to legislate in this area. So that is one issue that has come up. The items that are currently being looked at is specified as non-competes, and they may not be really looking at non-disclosure or non-solicitation clauses, but due to some personal experience, they are looking at what non-compete means and doesn't include other types of provisions. One of the other issues then that's being looked at, which we touched on with the DC law, is interim versus post-term restrictions. And then should there be carve-outs for reasonable restrictions with certain levels of employees, certain wage earners, folks who have access to information, how much access they have, and that sort of thing. Next slide, please. I think at this point, I think it's Robert's turn, and he'll start going into some of the restrictive covenant cases, the recent ones of note this past year.
Thank you, Michael, and thanks for joining us today. Next slide, please. In my session, I'd like to discuss some of the most significant restrictive covenant cases and trade secret cases that we've seen over the course of the year. In California, which is often used as sort of the shining star in support of banning non-competes at the federal level because of the viewpoint that it fosters innovation and employee mobility, we had a somewhat surprising case come out of the California Supreme Court addressing the issue of business-to-business non-competes, and that's the Biogen case. And in this particular case, the court was called upon to answer two key questions concerning the validity of a settlement provision requiring a party's termination of a collaboration agreement with a third party. And in the court's decision, the court unanimously held that to state a claim for tortious interference with an at-will contract, a plaintiff must allege that the defendant engaged in an independent wrongful act. But as it pertains to business-to-business non-compete, what the court said is that in determining the validity of a competitive restriction in a business-to-business agreement under Business and Professions Code section 16600, the rule of reason applies, and such restriction is not per se void. Now, I think a lot of prognosticators that were predicting what would occur in this case, I think they were somewhat surprised that the court landed in upholding business-to-business non-competes, at least in the form that it did, justifying business-to-business non-competes under the rule of reason analysis. And so one of the questions is, well, what does this mean? I think certainly in the context of an interim business-to-business non-compete, you're on pretty safe ground to include such a provision in the agreement, so long as you have a legitimate business interest. Where it's going to become more, difficult and more of a gray area is what about the post-termination restriction? How long? What's the duration? And so this decision is really going to impact how companies contracting under California law decide to set up their contracts and whether they will agree to at-will termination of contracts. And it also provides some clarity for businesses that include competitive restraints with other companies in their commercial dealings, such as exclusive dealing and collaboration agreements, license agreements, leases, and franchise agreements, with the courts holding that such restraints are not per se void under Business and Professions 16600. Next slide, please. And after the Supreme Court's decision, there was a companion case that had a similar holding dealing with the similar issues on the business-to-business non-compete. In this particular case, it was an exclusive dealing agreement between two biotech companies, and the court reiterated that there's no per se ban on non-compete in the business-to-business context, and that there's really going to be an application of the rule of reason standard in evaluating such agreements. And what the court said in the Biogen case, as far as the rule of reason standard, the court is asking whether the agreement harms competition more than it helps, considering the facts peculiar to the business in which the restraint is applied, the nature of the restraint and its effects, and the history of this restraint and the reasons for its adoption. So it will be a fact-based inquiry as far as why this particular business-to-business non-compete was included. Certainly, legitimate business interests such as the protection of confidential information and trade secret and customer goodwill will always serve as a legitimate, basis. And so I think what you're going to see in the future is how far this decision will be stretched as far as post-termination business-to-business non-competes. And certainly, employers are always looking to get the benefits of characterizing the relationship, which would otherwise be viewed as a contractor or a employee relationship, try to get the benefit of California law that allows non-competes in the sale of a business or under this new standard business-to-business non-compete. So I think you're going to see some creative lawyering as far as trying to take advantage of the more lenient rule of reason type standard. Next slide, please. It's another interesting case, and for you outside of California, you would probably have said, well, this is a no-brainer. But the California Appellate Court indicated that you can have interim non-competes with your employees. I think a lot of companies would have thought that they'd be covered by the duty of loyalty and that this would not be a controversial issue. But as many of you might be aware, nothing's entirely clear in the Bear state as far as restricted covenants and trade secrets. But at least on the employer side here, the court made clear that you can have intern covenants not to compete with your employee. And so, that's something in reviewing these agreements over the years that's often missing in a lot of employers' agreements is that they don't include the interim covenant not to compete. They're so conditioned that you can't have post-termination non-competes in the typical employment relationship that they forget that you can have interim covenants not to compete. And that's significant because apart from, tort law that may support you under the duty of loyalty, it's nice to have a contractual basis. And the real dispute and where the rubber hits the road comes in when you make those preparations to compete, which are typically protected under California law. And so where you're going to see some conflict in light of this new decision is if you can have this interim covenant not to compete, how does that harmonize with some of the established case law about you being able to make certain preparations to compete, such as making announcements to your customers. Next slide, please. One issue that comes up a lot in California is what's the current status of the law with respect to non-solicited employee provisions. And I think an important observation to note is that this concept of interim non-solicitation of employee provisions, those should be enforceable, certainly under the decision that we just went over. But the real controversy outside of the interim non-solicit, which I should note, a lot of employers don't include the interim non-solicit, which is significant because they're most likely enforceable under California law. But as far as the post-term non-solicitation of employee, there's currently a split of authority. The older authority based upon a Court of Appeal decision in Rhode, which is premised upon a rule of reason type of analysis, compared to a more recent case, the AMN healthcare decision, which is based upon the California Supreme Court decision in Edwards versus Arthur Anderson. And that continues to be a recurring issue. Some cases, some federal courts following the AMN rationale, which takes a broad and expansive viewpoint of California's prohibition against non-competes. And, from that perspective, even though I said employee non-solicit agreement, they view an employee non-solicit agreement as akin to a non-compete, and they apply the same sort of, strict scrutiny in evaluating that type of covenant. But we have seen some developments, and actually some, significant developments. There's some high-profile litigation going on right now in Los Angeles Superior Court by some of the entertainment giants, Fox, Netflix, and Viacom. And the issue has to do with fixed-term employment agreements. and whether or not you can have a tortious interference claim against a competitor who interferes with a fixed-term employment agreement with a California employee. And at least at the trial court level, that trial court has found that you can have a tortious interference claim. So effectively, if a competitor tries to hire your fixed-term employee who may be like on a 3, 4, 5 year, 6-year term employment agreement, you could state a claim for tortious interference for interfering with that relationship, notwithstanding California's general prohibition against non-compete. Interesting also in this particular decision that has been rendered is that the court also looked favorably on employee non-solicitation provisions, both in-term and post-term. So again, there's a lot of fluidity in California law as far as how this is ultimately going to shape out. I think the California Supreme Court will ultimately have to rule on whether or not the non-solicitation of employee provisions, at least post-term, are continued to be viable. Next slide, please. And another interesting decision that came out of California this year with respect to overly broad non-disclosure agreements. And this is, an important point for employers as far as evaluating what your non-disclosure agreements look like, how you define confidential information, and whether your definition of confidential information is so broad that it could be viewed as a de facto non-compete. Yes, that's true. California courts are not only looking to invalidate non-solicitation provisions, but they're also looking very closely at non-disclosure agreements. There seems to be no limit to the scrutiny that California courts will undertake and try to further employee mobility. And so this particular decision is definitely worth a read. Definitely compare it to your current non-disclosure agreement and make sure that your non-disclosure agreement is not so overly broad that you're basically trying to cover any and all information related to the industry in which the employee works. And typically arbitration awards are sacrosanct, and there's very limited areas to vacate those arbitration awards. But the Court of Appeal in the Brown management case was so concerned and and found that the arbitrator's ruling on trying to enforce this overly broad non-disclosure agreement was so invalid that they upset the arbitration award that was in favor of the employer. So a reminder to careful look at the scope of your non-disclosure agreement. Next slide, please. We had some additional significant cases coming out this year. First, in Massachusetts, with respect to a anti-rating covenant. In this particular decision, the court found that the anti-rating provision was legally enforceable, but ultimately the court found that the injunction was not valid because there hadn't been a finding on the record that damages would be inadequate. And this particular anti-rating was in the context of the buy and sell of a business, and the court rejected the other side's theory that the anti-rating provision did not serve a legitimate business interest. Another significant decision that came out in Massachusetts is that Massachusetts non-compete statute doesn't bar out-of-state employers from enforcing reasonable restrictions against Massachusetts employees. The particular covenant that was at issue in this particular case was a non-solicitation agreement. And the court found that first, the Massachusetts non-compete statute did not apply retroactively and did not apply to non-solicitation agreements. Another interesting aspect of the decision was that Massachusetts material change doctrine was inapplicable, where the employee chose to terminate their own position. Next slide, please. Significant decision that came out of Nevada, and we've seen some interesting legislation come out of Nevada in the last couple of years. The main issue with respect to Nevada and non-compete was is that what happens if the non-compete is so overly broad and the actual contract itself doesn't have a reformation or a blue pencil provision. And what this particular court said is that, so long as the contract itself has a provision that allows the court to, blue pencil or sever an offending provision, that's going to be enforceable. What had happened is in the Supreme Court Golden Road decision, the court in that particular Supreme Court decision found that since the contract itself didn't have a blue pencil provision, that the court could not reform or blue pencil the offending or overly broad solicitation covenant. And then subsequently, after that Supreme Court decision, Nevada passed the law that basically authorized Nevada courts to blue pencil non-compete agreements entered into after January of 2017. And then the question became, well, what about with agreements before that time period? And the upshot of the Duong decision is that so long as we're talking about agreements before January 3rd of 2017, and so long as the agreement actually has a blue pencil provision in it, the court is free to blue pencil what may be an overly broad non-compete. Next slide, please. A significant decision coming out of Nebraska, and this is interesting issues that comes up in restrictive covenant cases all the time about choice of law and choice of forum, and how choice of law and choice of forum can often be outcome determinative. And in this particular case, Cabela's, the argument was whether or not the court should apply Delaware law, and the court found that Delaware law should not be applied because the non-compete agreement would not have been enforceable under Nebraska law. Oftentimes, these decisions go both ways, and oftentimes it depends upon who's making the determination, whether it's the Court of Appeal in Nebraska circuit, or whether it's the Court of Appeal in the Delaware circuit. And oftentimes it can, it depends upon what the real nexus is to choosing Delaware law, whether or not the incorporation of the company in Delaware is sufficient, what the amount of the contract in value is, whether there are any other sort of connections to Delaware. And so oftentimes they apply, the restatement, and this analysis can often be outcome determinative in a non-compete dispute. Next slide, please. And then lastly, to summarize on the updates on the non-compete, there was a significant decision coming out of the Fifth Circuit. The Fifth Circuit addressed the issue that's presently undecided by the Texas Supreme Court, namely whether reformation of an overly broad non-compete restriction is appropriate and perhaps even acquired at the preliminary injunction stage, or must occur as a remedy after a trial upon the merits. The Fifth Circuit held that reformation of an overly broad non-compete agreement was warranted at the preliminary injunction stage. And so this is going to be a significant case under Texas law. And so if you have if you're attempting to enforce or defend against the enforcement of a non-compete in Texas, it's definitely worth checking out this case to see how it may apply to your particular circumstances. With that, I'd like to turn to a brief update on some of the more significant Defend Trade Secret Act decisions that we've seen. Next slide, please. There was an interesting report that came out in 2020 regarding trade secret litigation. And some of the conclusions that came out of this report is that they saw an increase in federal trade secret filings after the enactment of the Defend Trade Secret Act. And that nearly 3/4 of all federal trade secret filings in that past year and had included a DTSA claim. And they also found an increase in the number of Computer Fraud and Abuse Act claims post passage of the DTSA. As far as analyzing what these particular cases involved, they found many involving insurance companies and the financial services industry. And they also found that the courts were more likely than not to grant requests for preliminary injunctive relief and granted PIs nearly 80% of the time for permanent injunctive relief. Plaintiffs fared better during jury or bench trials, while defendants fared better at summary judgment. And then oftentimes the particular jurisdiction where the case was brought was a key factor in the final outcome. Next slide, please. There was a significant case that came out of the Ninth Circuit this past year dealing with respect to the statute of limitations. And this was actually in December of 2020. The California Court of the U.S. Court of Appeals in the Ninth Circuit held for the first time that a misappropriation claim under the DTSA may be brought for misappropriation that started prior to the enactment of the DTSA, as long as the claim also arises from post-enactment misappropriation or from the continued use of the same trade secret. And so the decision further expands the reach of the DTSA and provides a blueprint for other courts to rule along the same lines. Next slide, please. Another significant issue under the DTSA that we're beginning to see significant case law on is extraterritoriality. And what that basically means is whether there's foreign actors involved, and what do you need to show in order to bring a claim where the trade secret misappropriation has to do with foreign actors and may involve foreign misappropriation. And it is appearing that the Defend Trade Secret Act is going to provide at least some recourse in cases that deal with foreign actors. The big issue comes up as far as whether the Defend Trade Secret Act has any sort of extraterritoriality aspect. Many federal statutes, state-passed statutes, don't necessarily apply for foreign actions. And so there needs to be some sort of tether that would apply that actions taken abroad or that have some sort of impact on the United States that the statute would actually apply. And so what we've seen in the V personalized case and the Motorola case is that the courts, the federal courts, have been willing to find that the DTSA does have extraterritoriality, and they're basically using Section 1837 of the Defend Trade Secrets Act, and that's actually a carryover from the Criminal Economic Espionage Act, and it says that that the chapter applies to conduct occurring outside of the United States in two circumstances: where the offender is a natural person who is a citizen or permanent resident alien of the United States, or an organization organized under the laws of the United States or a state or political subdivision thereof, or an act in furtherance of the offense was committed in the United States. And so for large companies that have that have international reach, international business, this is a good development to protect their IP, because if they can show the offender is a citizen or the company is organized under the laws of the United States, or there was an act in furtherance offense committed in the United States, you can bring a claim under the DTSA. The significance of the V personalized case is that act in furtherance does not even need to be committed by the defendant. In that particular case, it was a misappropriation claim, and there was a third party that was involved in the stream of commerce, and that was sufficient for the court to find that you could maintain the claim under the DTSA. Next slide, please. Some other notable decisions, and one came out of the Ninth Circuit having to do with the requirement to identify trade secrets with particularity. Now, some pundits have said, well, this demonstrates that there's a difference in state and federal court, at least in California, about the requirements to identify trade secrets with particularity prior to commencing discovery. But I think I would challenge that notion. In this particular case, what happened is upon the opening of discovery, the defendant brought a summary judgment motion and sought summary judgment that the trade secrets had not been identified with sufficient particularity. The district court granted the motion, and then on appeal, the Ninth Circuit indicated that the granting of summary judgment was not appropriate. Obviously, it was very early in the case, and the plaintiff hadn't had an opportunity to do any discovery or try to supplement their trade secret identification. So that particular decision may be limited to its facts, but it's often something that's very significant in trade secret litigation as far as what is the requirement that the court is going to impose on the identification of, what exactly was taken before they open up the gates as far as discovery goes. Another significant case that came out of the Third Circuit is that the court found that just the lawful possession of a trade secret without ownership can be sufficient to maintain a misappropriation claim. Now, that particular case was under Pennsylvania's adoption of the Uniform Trade Secret Act, and so it may not have applicability under the DTSA, which speaks in terms of ownership. Another significant case was the CompuLife software case. And in this particular case, the defendant was using bots to scrape web data from the internet of a particular company. And, the argument on the other side, or from the defendant, was, listen, this stuff's on the internet. We should be able to use bots to take that data. But at least in the 11th Circuit, the court found that using the bots, using of these technological mechanisms, could constitute improper means and misappropriation of a trade secret, and is somewhat akin to doing a flyover or using a helicopter to spy on a competitor's manufacturing plant or something of that sort. That kind of analogy, and then another significant case we saw in the Southern District of New York having to do with trade secret case that was allegedly brought in bad faith, and that the defendant attempted to seek attorney's fees for the alleged wrongful pursuit of the trade secret case. The court found that the award of attorney's fees requires that the claim that was to be wholly without merit. So with that, I think I will turn the presentation over to my colleague for some additional trade secret cases.
And now's a good time to give you guys the CLE code. So the code is SS as in Seyfarth Shaw 7660. That's SS 7660. So in the interest of time, we're just going to briefly cover some of the notable trade secret cases that we saw within the past year. There were a number of notable damages awards in the 9 figures amounts in the Epic case, Motorola, and Cognizant case. Actually, in the Motorola case, which Robert had mentioned, that favorable ruling for plaintiff regarding extraterritoriality allowed them to survive through until trial, and then ultimately prevail and get a jury award with $764 million and about over $400 million of those in punitive damages. One of the cases on this slide that stands out is the Court of Appeal decision in the Jaxo versus E-Trade case. This is significant because the court held that the Georgia Pacific factors could be used for trade secret damages analysis. This is actually the first time that the Court of Appeal in California adopted this patent royalty framework from these Georgia Pacific factors and clarified that they could be used to determine the reasonable royalty under the California Uniform Trade Secrets Act. So it does at least provide some clarification regarding that analysis, but there are some concerns that that decision may not have provided enough predictability for that calculation for litigants. Next page. So reasonable secrecy measures always continues to be a key issue with trade secret cases. About a decade ago, we were presenting this webinar, and the issue of social media was becoming really a serious concern with courts looking at how the impact of different social media websites such as LinkedIn had on the secrecy of confidential information such as customer contacts, customer preferences. And I believe it was the Eagle versus Moran case where the court noted that the technology is just evolving so rapidly, and the courts are just moving at such a slower pace that they're struggling to keep up. And so what was traditionally considered to be secret information or reasonable secrecy measures, before may no longer be, sufficient as the technology evolves. Two key cases to be aware of: the Amgen case from the California Court of Appeal and the ultimate timing case. It was a Washington District Court case. The courts had somewhat different interpretations regarding confidentiality disclaimers in emails, although the facts are somewhat distinguishable. In the Amgen case, the court noted that an email that was sent with some confidential pricing information, that email had a disclaimer in the subject line and the text of the email that indicated that the information was confidential, but the court found that that email blast to over 170 recipients, those disclaimers weren't sufficient to maintain the secrecy alone, and especially the court noted that the recipients didn't have another obligation or any contractual agreement to keep that information confidential. On the other hand, in the ultimate timing case, this case involved some information that was allegedly used regarding some race timing systems. The plaintiff had alleged that one of its investors used this confidential information to develop a competing product with a third party. The defendants argued that the plaintiff hadn't used reasonable secrecy measures and pointed to the fact that the plaintiff had allegedly shared this alleged confidential information with another third party in an email. The court noted that the plaintiff did not have a signed NDA with that third party recipient, but the court did noted that the plaintiff had at least requested that recipient maintain the confidentiality and secrecy of that information. So between the Amgen and the ultimate timing case, you can see how the difference between 170 recipients versus one recipient is somewhat distinguishable, but the courts are being aware, and it kind of just reiterates the importance of having enforceable non-disclosure agreements when sharing information with third parties. One case that is really timely in light of the change in the workforce and the ongoing impact of the pandemic on where employees are working, how they're accessing data, is the Smash franchise case. In that case, the court noted that there was some confidential information allegedly disclosed during a Zoom meeting, but the court found that the information lost secrecy because the alleged trade secret holders and who were organizing those Zoom meetings were not requiring passwords. They were not keeping track of attendees and participants. And the issue came up in that case was a meeting ID was shared where some of that confidential information was disclosed, but it became apparent that that same meeting ID or link could be used subsequently for any future meetings. And so there was kind of this kind of open, unprotected access to information. And so the court thought that because Zoom had all these additional secrecy measures and those were not being used, that the information did not maintain its secrecy. Next slide. And there's a few notable cases. The Aerotech case, one of the issues was for attorney fee awards, who does the award belong to? Is it the attorney or the client? And the court found that absent a express retainer agreement, the award actually belongs to the attorney. The In re Hill case, the Sixth Circuit found that a default judgment of willful and malicious trade secret misappropriation was not dischargeable in Chapter 7 bankruptcy. In the Zotec case, the Fifth Circuit held that the Texas anti-SLAPP statute could not be used to defeat a trade secret theft lawsuit. In that case, the defendant had moved for dismissal under the state free speech law called the Texas TCPA, which is designed to bring a quick end to baseless lawsuits brought to that are perceived to chill First Amendment rights. The defendant had argued that that lawsuit infringed both their right of free speech and association, but the Texas Sixth Circuit Court of Appeals rejected those arguments and noted that the TCPA must apply to communications that involve a matter of public concern. Next slide. With that, I'll turn it over to Mike Wexler.
Thank you, Josh. One of the things we wanted to discuss also with you are some cases regarding criminal cases. Van Buren versus United States is a case and an interpretation that went into what is the term exceeds authorized access, because there's a split among the circuits as to what authorized access is. So for example, someone could go into the computer system with regard to an employer, take things out clearly for a non-company purpose, clearly for a competitor or other purposes. And what does that mean exactly? One would say, well, that's not an authorized purpose. So that, of course, has to be exceeds authorized access. And the circuits are split on that, actually. There are some circuits that say if you're allowed to be in the system, even if you do it for a purpose that's not for your company, then potentially that access is not exceeding authorized access. And so there's all argument heard on November 30th with regard to this, and the arguments talk about the language of the statute, and there's criminal case aspects of the Economic Espionage Act as well as the Computer Fraud and Abuse Act, and there's civil cases. And so the court, we're waiting for a decision, and we're waiting to figure out what is the court going to say as to what authorized access means and get rid of this split in the circuits. Next page. Another case, Sanig versus Barr, a 2002 case. There was, and it's of actually that's a typo, but the issue is folks that were looking at, university professors that were looking at computers and employment websites, trying to and look at the algorithms and to try to figure out whether or not there was improper discrimination based on race and gender. And the thought was, well, whether or not the statute, whether or not that kind of conduct could violate the statute, and there's a challenge that was made to the Computer Fraud and Abuse Act, saying that that if that activity is potentially criminalized, is that chilling the First Amendment rights to free speech by looking at these things? And of course, websites are certainly publicly available. So ultimately, the conclusion was that the Computer Fraud and Abuse Act does not criminalize mere violations, and so. Just something to be to think about and to consider when folks are looking at public websites and mining information from public websites. Next slide, please. Recent trade secret criminal cases. You can see that there've been a number of cases, and these are just a highlight here. One case, a Taiwanese semiconductor company, it was ordered to pay a substantial fine because of criminal trade secrets theft. An Ohio man, pled guilty to conspiring to sell trade secrets, which related to research that was being done at Children's Hospital and was sold to China. A Chinese national was sentenced the past year for stealing trade secrets worth $1 billion. You may have noticed in the pardons that were given out, the individual that was incarcerated with regard to the Waymo case was actually the Google Waymo case was actually pardoned by the president. Next slide, please. And then we just want to give, we're almost out of time here, so just want to give a couple considerations with regard to drafting considerations and practical issues. Because a remote workforce is prevalent based upon the last year's events, it's important to look at your agreements and to evaluate how your agreements are applied depending on the location and the access that folks have to information as they're working from home. You want to make sure that you have concise and clear computer and intellectual property technology policies as to what conduct is appropriate, what conduct is not appropriate, and protect these things. You also want to make sure you look at your choice of law and forum selection clauses. This is a substantial issue. There are states that have been legislating as to whether or not you can have choice of law and venue provisions outside of the particular venue, California being one of them, the 925 statute. You also, so that's an important consideration to discuss with your counsel what choice of law and form you are using in your agreements. You want to look at whether or not a template can be used. Do you need multi-state versions of agreements? One for every state, one for multiple states, one for all the states. Should you have exceptions within that one document? All considerations as you do these things. And finally, you should also think about how these agreements are executed. Are they executed in hard copy, electronic? What's the consideration being given in exchange for agreements that you're having folks sign? And also, you need to be very aware of storage and accessibility. How are people storing things these days? And what policies, procedures, and agreements do you have that apply to those to adequately protect those items? So that's also an important consideration. So finally, two things. One, there's a question about whether forfeiture provisions in non-competes that forfeit equity, whether those will be affected by these statutes. I think every state law is different. And for example, some states will say that forfeiture of equity is being a negative result of violating non-compete certainly may be affected by recent changes in non-compete law. So that's something to certainly consider. If you want to get up-to-date information on trade secrets, non-compete, computer fraud cases, you can go to our award-winning tradesecretslaw.com website. We are constantly updating that. Also, as mentioned previously, let us know through the website if you want a copy of our 50-state survey that goes into non-compete and trade secret and computer fraud issues in a very concise and summarized format in chart form. It's been a highly regarded publication we've put out for several years now. If you'd like to get that, you can certainly register for that through our website. And finally, again, if you want to reach out to any of us, if you have any questions, please feel free to do so. And again, check what's going on at tradesecretslaw.com. It's extremely informative. It's up to date. It's very thorough. And we're glad if you can use that as a resource to get additional information and answer some of your questions and thought and create discussion. So on behalf of Josh Salinas and Robert Milligan and myself, we're glad that you could join us. There's our contact information should you wish to email us or telephone us. Again, thank you for attending once again our summary of the prior year, and please feel free to reach out if you have any questions or things that we might be of service to you for. Thank you so much.